Last night, a federal judge in Portland, Oregon, rejected the Trump administration's request to immediately lift her order blocking the deployment of federalized National Guard troops to the city, adding that she will make a decision Monday. An appeals court also put on hold an earlier ruling that would have allowed the deployment of the Oregon National Guard. In a surprising move, the president called off plans to send troops to San Francisco, writing on Truth Social that the decision came after pushback from both the city's mayor, Daniel Lurie, and Trump's friends who work in the tech industry. And in Chicago, a federal judge indefinitely extended a temporary restraining order barring Trump from deploying National Guard troops to Illinois until a further ruling comes from the Supreme Court. Joining us now, Attorney General for the state of Illinois, Kwame Raoul. Attorney General Raoul, welcome back to the weekend. It's like you're here every week. Not that we mind. Thank you very much for being here. Just how do you anticipate the Supreme Court will weigh in on sending troops to your National Guard troops to your state?
Well, I mean, the core question is one of how much discretion we give to the President of the United States. I heard you all talking earlier about immunity. The court previously gave a lot of discretion to the President with regards to immunity. Here the question is, when is it okay for a president to militarize our cities? And the core question is whether the president has the discretion to determine when the prerequisites exist, or whether the president has the discretion after it's determined that the prerequisites exist to deploy. And there's a difference between the two, because if we say that, let's say that there are 20 kindergarten age children rushing the ICE facility, and the president says, "Oh, that's a rebellion." If we give that much discretion to the president, then it's game over. He can militarize our cities whenever he wants to, and that's a dangerous situation. If we instead say that there's got to be a really objective criteria of whether we're under a foreign invasion, or whether there's a rebellion, or whether there's an inability to carry out federal law, which is what we believe. And we believe that is subject to judicial review, then that's a more rational position.
But do you think this Supreme Court is going to lean to what you just said? Because when you look at the kind of facts, if you try to take Trump out of it, the President of the United States having the ability to send the National Guard in, or to, militarize the National Guard, call the National Guard in states against the wishes of governors, has happened in the past. The last time that it happened before it happened in Los Angeles was during the Civil Rights Movement, right? And so do you see them kind of carving out here's the criteria, here are the kinds of things that presidents are allowed to send the National Guard for? Otherwise, I think they will just give the president more the power that they've always had, which is when you feel like it's happening, it happens. And if someone ends up, abusing that power in your eyes, that might just be the cost of business when it comes to the president and the power of the National Guard.
Well, our Constitution, through the militia clauses, has given that power to determine the kinds of things to Congress. And so Congress has laid
they ain't working, sir.
Even when they are right.
So Congress has laid that out in terms of the three criteria that I laid out: foreign invasion, rebellion, and inability to carry out federal law. What the federal government is arguing, what the DOJ is arguing, is that the president has absolute discretion, and it's not subject to judicial review to determine whether any one of those prerequisites have been made. And that is dangerous. I mean, we already see what's going on in terms of bombing of ships and so forth without consultation with Congress. If we basically say a president of the United States at any time can say, hey, I can militarize any city, I can turn the military against any city in the United States. It's interesting that Judge Perry in our case went back to the Federalist Papers and the founders and said that And the founders, I think it was Hamilton, who said, it's implausible that any president would seek to send the militia of one state into the other. That's impossible. It would never happen.
Yeah, and here we are.
Attorney General, I want to ask you about some other breaking news that happened this week, which was President Trump calling off plans to send the National Guard and troops to San Francisco after he received pushback from Mayor Daniel Lurie and also Trump's friends who work in the tech industry. But Mayor Lurie, who is obviously a Democrat, fairly liberal, and this was not without criticism, took a very different approach to dealing with the Trump administration in trying to get the National Guard off his back by taking a low-key approach, calling his contacts in the Trump administration and trying to use those levers to protect his city in his own way. It is a markedly different approach than we've seen from some other mayors. What is your reaction to that? And do you think that mayors who are potentially face this situation in the months and years ahead with this president who seems very eager to continue to deploy the National Guard, that this more conciliatory approach is something that they should be taking a page from?
Excuse my French, but kissing the ass of the president should not be the prerequisite of whether or not our cities are militarized. Again, the prerequisites are set out by Congress, and it shouldn't be whether or not a particular mayor or a particular governor falls out of favor with the president. That's a dangerous prerequisite to set as to when our National Guard is federalized. If I don't like you this week, I get to send the military into your city. That makes no sense. That's not what the founders had in mind, and that's not what Congress has laid out.
Mm-hmm. Attorney General, really quickly, I'm going to get in trouble with the producers, but I want to play some sound from Stephen Miller on the Will Cain show, floating arresting your governor and some others, and get your reaction on the other side.
So if you engage in a criminal conspiracy to obstruct the enforcement of federal immigration laws or to unlawfully order your own police officers or your own officials to try to interfere with ICE officers or even to arrest ICE officers, you're engaged in criminal activity. Different kinds of crimes would apply. There's obstruction of justice. There is harboring illegal aliens. There is impeding the enforcement of our immigration laws. And then as you get up the scale of behavior, you obviously get into seditious conspiracy charges, depending on the conduct, and many other offenses.
Your reaction to Stephen Miller, who's the deputy White House chief of staff, saying that they can arrest officials over immigration enforcement?
Likewise, we have state laws, right? And ICE does not have a license to commit battery against our citizens, to step way out of their, they have a certain level of immunity, but it's not unlimited. And so this threat coming from Stephen Miller, who's not the greatest legal authority, is a bit hollow. I should say that even by the representation of ICE officials, our local law enforcement has kept the peace, right? Has worked to keep the peace, outside the ICE facility and in other places. And so we've demonstrated that our sovereignty should be respected, and our ability of having local law enforcement do its job is carried out adequately by local law enforcement.
Illinois Attorney General Kwame Raoul, thank you so much for coming on The Weekend once again.
Thank you.